Hi, welcome to this Tutor to You A-Level Politics topic video taking a close look at the nature of the UK's constitution. Now, before we take a look at the various elements and features of the UK constitution in depth, it's worth just taking a little moment to look at a summary that's here on the screen. We'll be starting our topic video at the very top of our little diagram there, looking at what is meant by an unentrenched or flexible constitution. We'll be working our way round that circle in a clockwise direction, looking at uncodified constitutions, unitary constitutions, and then the final two there, parliamentary sovereignty and the rule of law, which A.V. Dicey famously regarded as the twin pillars of the UK's constitution. So, unentrenched and flexible constitutions. This is certainly a description of the UK constitution that you'll hear quite frequently. What we have on the screen here on the left hand side are some of the reasons why arguably it is unentrenched and flexible, and in other words that's a good thing. And then on the right, the view that actually the UK constitution is far too easy to change. So let's start by taking a look at what we mean by unentrenched or a flexible constitution. In very simple terms, it means that there is no formal change process, as there is, for example, in the United States. The UK constitution can change by a mere act of parliament or a new custom or tradition that develops, in other words, a new convention. It also changes as the government signs international treaties, as people make comments and commentaries on the UK constitution. So it is very, very straightforward to change for the most part. And you can argue that that's a really good thing in that it allows our constitution to really keep up with contemporary society and be easily reformed to match society's preferences, cultural changes, and so on. For example, the Fixed Term Parliaments Act was introduced in 2013, and that was intended to set out 5-year intervals between the UK's general elections, and that was essentially meant to help prevent executive dominancy. In other words, the executive, the ruling government of the day, calling the election, the next general election, whenever it would give itself the highest chance of performing well in that election. So that was very easily introduced to a reasonable amount of parliamentary support. However, we also saw that it was extremely easy to effectively overturn the legislation and call a 2017 general election in order to give Theresa May, hopefully, well, in her mind at the time, a stronger mandate to carry through and push through her Brexit negotiations. Secondly, the UK constitution does have this patchwork of sources. We have statute law, we have common law, we have international treaties, we have conventions, we have authoritative works by highly regarded authors. And this patchwork and interweaving of the sources actually makes the UK constitution just about difficult enough to change and to unravel. It's not easy to really unwind several hundred years of history. That's very much in evidence with the complexity of the process of leaving the European Union, all the little bits that have to be unravelled and unrolled in order for that to happen. On the flip side, it could be argued that in fact change is too easy, and certainly there is far more constitutional change than there is in countries that have a codified constitution, in other words, where their constitution is written in one single document. Arguably, the calling of the Brexit referendum to claw back some Tory support from UKIP is a good example of the constitution ultimately having to be amended just to suit short-term political objectives of the Conservative Party. It may also be the case that changes become so frequent that they actually become fairly incoherent. The different changes don't necessarily match together, and no one necessarily has oversight over everything. The second feature of the UK Constitution that we're going to take a look at is the fact that it is regarded as uncodified. Now, a codified constitution is one that is written in one single document. The UK's constitution is uncodified. It is not written down in one place. Don't confuse that with it being unwritten. There are numerous elements of the UK constitution that are indeed written, for example, statute law and the works of authority, and of course any international treaties that we have signed up to. But uncodified constitutions are relatively rare. There are some examples there shown for you: Israel, the UK, New Zealand, Saudi Arabia. But many countries that have uncodified constitutions are starting to codify certain elements of them, if not moving towards full codification. And it's certainly a key debate amongst constitutional theorists in the UK as to whether the UK should have a codified or an uncodified constitution. That particular debate is covered in another of our topic videos. Now, the UK constitution being uncodified in turn generates a number of features. Now, firstly, we've already established that it is quite rare. There are, of course, many sources, and this helps to give us a sense of culture and history. It is partly written in terms of the statute law, works of authority, and international treaties. Conventions, by their very nature, are not written and are customs and traditions, although you will, of course, find a lot of written reference to those conventions. It's also very organic. An uncodified constitution can be regarded as organic. The constitution can change and develop. One great example of this is how Ron Davies, the former Welsh Secretary, described devolution as a process, not an event. We can also regard an uncodified constitution as resilient. It stands the test of time. There is no major reason to change it. It can adapt as and when is needed, and parliamentary time does not need to be devoted to debating and agreeing changes, specific word for word changes in a constitution. A third feature that is really important when we're looking at the UK constitution and the so-called Westminster approach to the political process is that our UK constitution is unitary. The UK is a unitary state. This means that the central government, in other words, Westminster, has supreme power over all other areas and all other forms of government within the country. There may, of course, be lower parliaments, for example, the Scottish Parliament, similarly with the Northern Ireland Assembly, but they only have powers that have been specifically granted to them by central government. Central government is able at any time that it chooses to reverse those powers and take them back. Now, in the UK, the devolution process seems fairly unlikely to be unwound with the returning of all power to Westminster, but it could happen. Many countries operate a unitary system, but there are some significant countries that do not. Countries that you will meet as part of your A-level politics course, for example, might be the USA. Now, the USA is regarded as a federal state, federal country, not a unitary country. Yes, there is central government in the form of Washington and the Washington institutions, but each state also has its own government, legislature, judiciary. Those states in the United States have what are called reserved powers. They have powers that are purely for them, and those are set out very specifically in the US Constitution. A very small number of countries are what we call confederate countries. An example fairly close to home would be Switzerland, where each region or area has its own government and there is very little central government in operation. In terms of looking at how the UK Constitution has changed, many people do still regard it as unitary because Westminster does have the power over all of the other local governments and devolved governments. But you could perhaps now describe it more correctly as quasi-federal. Central government, Westminster, is still in charge, but it just seems so unlikely that they will withdraw any of the powers from Scotland, Wales or Northern Ireland. that it's beginning to look a little bit more like a federal state. So what are the advantages of being a unitary state? Well, firstly, it can create a sense of belonging. Instead of having different parts of the country effectively pitted against each other, there is a sense of national belonging. It can make it easier to manage the economy, collecting taxes in one area to spend elsewhere, for example, helping to reduce perhaps inequality or spend on infrastructure, such as roads and railways. It may also avoid the duplication of services, and this can save the taxpayer money. Arguably, a unitary state might find it much quicker to respond in the case of large emergencies. The national government is able to intervene at any part, any point, any location within the country without treading on the toes of local government. It's also regarded as fairly flexible. We have local government, devolved government. There are a number of different lower levels of government that are possible, and they can be matched to local needs. It can also provide strong, stable, and effective leadership from the centre with an overview over what is best for the economy and the country as a whole. However, a number of commentators regard unitary states as being out of touch. The central government may just simply be too far away from different communities, particularly if those communities are geographically distant or actually very different in terms of ethnicity, culture, background, history. One phrase we often see used here is urban supremacy. So the role of cities, the importance of cities might be overemphasised because that does tend to be where central government is located. There may also be fewer checks and balances on central government. Lower levels of government may find it much harder to hold central government to account because of the risk of losing their status or perhaps losing their funding. In terms of individuals, the response time to concerns or even petitions may be quite slow if there is only one government channel. If all issues have to be channeled into central government, that can be quite challenging as opposed to finding the local areas and the local access points that might be more beneficial. Arguably, there's less diversity, fewer opportunities for people to participate in government and politics because there is really just the one main level, and arguably fewer local initiatives at the expense of national initiatives. So now we're on to the final two areas, the final two features of the UK Constitution, and arguably two of the most important. So we have parliamentary sovereignty and the rule of law. So what is parliamentary sovereignty? 4 key features. Parliament is really the only institution that can create or end a law. Legislative authority rests with Parliament. In the UK Constitution, the courts cannot overrule Parliament. Yes, they can make recommendations, or in the case where the Human Rights Act might be in conflict with an Act of Parliament, they can issue a declaration of incompatibility, but that does not require the UK Parliament, Westminster, to make any changes at all. Furthermore, Parliament is never binding on its successors. One Parliament can never restrict the actions of a future Parliament. Any future Parliament is able to unmake the laws. For example, the 1972 European Communities Act, introduced by the Heath Conservative government, are being undone via the Great Repeal Bill following the referendum on Brexit in 2016. So where does parliamentary sovereignty come from? What are its sources? Well, very little of it is actually written down. Again, remember, we have an uncodified constitution. So parliamentary sovereignty comes from a number of places. Firstly, in my mind, is the idea that Parliament's lawmaking ability has effectively been unchallenged. No other group has sought to change the law. Secondly, the courts in our country enforce the acts of Parliament. That gives them legitimacy. Finally, parliamentary sovereignty has been achieved over time through culture and historical changes. So at the bottom there, A.V. Dicey's very famous quote, on parliamentary sovereignty. This is definitely one that is worth learning and actually including in any exam answers. So, has parliamentary sovereignty been undermined? Arguably, yes, it has. So, devolution could arguably have undermined parliamentary sovereignty. Many of the regional governments, so for example, the Scottish government, has a significant amount of power. For example, the ability to change taxes, have its own education system, its own healthcare system, operate its own railways, deal with alcohol restrictions and so on. Some fairly fundamental features of the law. The Human Rights Act, introduced by the Blair government in 1998, now gives judges the power to issue these declarations of incompatibility, which require the UK government to take another look at any acts of parliament that might contravene the Human Rights Act. That said, there is no reason at all for the acts of parliament to actually be changed. UK membership of the EU, a very topical issue. Yes, I think it probably is true that parliamentary sovereignty has shifted slightly towards the EU. Our topic video looking at the historical developments of the UK Constitution takes a closer look at some of the background to this, in particular the 1972 European Communities Act. EU regulations must be applied directly in UK. EU directives are adapted by the UK into our own law, but we cannot pick and mix which bits of EU law we want to use. So yes, we must adopt EU law while we are still members of the EU. The classic case here that students really should know is the factor tame case. This played a very key role in the debate over the location of sovereignty in terms of Britain's membership of the EU. This case really took place in the early 1990s. It ran on for some time. It was a complicated case. It related to Spanish fishermen fishing in UK waters and then selling those fish in Spain. The UK government did not think that this was acceptable, but it had to go to the European Courts of Justice because of the conflict with EU law. And the EU law ruled that indeed the Spanish fishermen were well within their rights to fish in UK waters. The establishment of the Supreme Court in 2009, following the recommendations in the Constitutional Reform Act of 2005, arguably changed sovereignty in the UK, changed parliamentary sovereignty by giving judges a little more power to challenge the government. There continues to be the need for royal assent for acts of parliament, although it is of course a very strong convention that the monarch does not withhold the royal assent. Finally, Parliament Acts do not require consent of the Lords for all new laws. The power of Westminster has diminished, but most of these acts and changes can all be undone by future parliaments. In other words, no parliament has been binding on its successor. They were introduced by parliament. They can be removed by parliament. Another key debate is whether, in fact, what we really have is House of Commons sovereignty rather than parliamentary sovereignty. Certainly one to have a think about. And not all bills, however, do originate from government manifestos or from the Commons. Finally, we're taking a look at the rule of law, in other words, democracy. What this means is that the law applies equally to everybody and that no person, including politicians, is above the law. A person should not be punished unless they have breached the law. And this is the twin pillar of the UK Constitution according to Dicey. Law governs the nation. It is not individuals that govern the nation. There are some key debates in relation to the rule of law at the moment. Firstly, the rule of law is regarded by most development economists and most development activists and theorists as being actually quite important in terms of helping other countries and economies to develop. So the rule of law will help to uphold contracts, for example, and that in turn can stimulate investment and help support economic growth and development. Gun ownership in the US and in other parts of the world as well. To what extent does gun ownership either promote or negate the rule of law? That's certainly one to go away and have a good debate and good think about. UK terrorism laws still allow 14 days detention without charge of suspected terrorists. Does this undermine the rule of law in the UK? If we look more recently at the media coverage of the Brexit referendum and the very famous front page picture on the Daily Mail regarding judges as enemies of the people, certainly some of the Supreme Court justices believe that this certainly undermined the rule of law in the UK. For more topic videos, do take a look at the Tutor2You website, and just generally for more advice, guidance and support. Thanks so much for joining me today.